Okay, now here's something important coming up. Point 16 is for men only who have had to enlist in selective service. Continuing, 12 Presumptions of Law, Legal and Lawful, Judicial and Clerical Notice, Part 3. 15. The term parens patriae is Latin for parent of the country or homeland. Under parens patriae, a state or court has a paternal and protective role over its citizens or other subjects to its jurisdiction. I again challenge that the parens patriae doctrine is not valid, not legal, and not lawful, and that the court cannot prove all three, valid, legal, and lawful, in a written statement subscribed and sworn or affirmed and attested under their full commercial liability and under penalty of perjury. 16. Men have been enlisted into selective services at the age of majority. That does not give authority to judges to act upon that enlistment as surrendering of rights and/or as a reason for loss of status. It presumes nothing other than that the people involved are honorable men who are willing to put their lives on the line in times of war and national emergency. 17. According to Canon Law 32.28, a court does not operate according to any true rule of law, but by the presumptions of law. I hereby challenge the presumptions of the Bar Guild, so they do not and will not furthermore stand as truth in commerce for all government agents, civil officers, involved in this matter or which may be involved in future interactions with me or my person. 18. Public record. Because I am not a private guild member, I hereby decree that this is a matter to be placed on the public record now and remain on the public record forevermore. Any and all government officers, agents, judges, magistrates, referees, justices of the peace, and any such title are hereby bound to only obey their oath in accordance with Title 5, Section 3331, United States Code annotated, and either recuse themselves or denounce their secret oath or oaths to any organization which were made previous to their public oath. 19. This matter is not to be held convened under the private bar guild rules, but rather in a court of trust law, common law, and maritime law, under the rules of the United States Code, USC, or also known as Title, specifically but not limited to Title 5, 7, 8, 9, 12, 15, 18, 31, and 42. Also under the rules of the canons of law, also under the rules of maxims of law, as listed in the lawfulpath.com website. And finally, under the state or federal rules of civil procedure, whichever of the two choices, state or federal, is appropriate. You and each of you are hereby bound to obey your public oath to serve the public. 20. Regarding public record, I have recorded my paperwork with the county recorder and a notary public. Make sure that that is true for you. Sometimes you just file them with the clerk of the court, so put that in. Any matter brought before a lower court is a matter for the public record, despite the fact that it presumed by the members of the Bar Guild that the matter is a private Bar Guild member business matter. I hereby openly rebuke and reject secrecy as well as holding of a closed meeting for Bar Guild members only, by stating clearly that this controversy is on and is to remain on the public record. 21. For our purposes here, all members of the private bar guild have sworn a solemn and secret absolute oath to the guild, then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oath to the guild. And unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under the public oath. I do here and now administer that all agents involved in this matter who wish to maintain their secret absolute oath may do so. However, if they choose to do so, they must recuse themselves from this controversy and replace their office with an officer who is willing to rebuke his secret absolute oath and proceed only as a public officer / public agent, with his only allegiance to remain as a public official, officer, or agent. By remaining involved in this controversy, such will be deemed prima facie evidence that all agents, officers, officials, and all such titles proceeding in this controversy have agreed to these terms and will act and operate only in their capacity as a public agent, officer, official for the remainder of these proceedings and face potential criminal and civil liabilities for violating the public trust. Faith. To be clear, judges, magistrates, etc. To be clear, judicial, judges, magistrates, etc. and or clerical immunity, clerks at every level and subdivision, is hereby void. And that's the end of part 3. Now, a couple of things that are real important here is to realize that they are doing a private guild member and a public court hearing. The public can witness it from the gallery. So we want to make sure that they hold a court of common law. But as it says earlier, we can go into the other jurisdictions. We just put it that this is a court of common law. But they can go into courts of admiralty, maritime law, or chancery, trust law, contract for multiple jurisdictions, as I've mentioned in other videos.